Initially, let's recall that a living trust that avoids probate, makes sure that no unnecessary estate taxes are payable, and distributes assets to your heirs is the basic death plan. However, a living trust that adds incapacity protection, spousal protection, child protection, and grandchild protection is a life plan. In other words, a life plan provides the essential elements of a basic death plan, that is, probate avoidance and unnecessary estate tax protection elimination, but adds substantial protection for those you care about most. Let's talk about each of these protection areas in a little more detail. Your living trust should have an entire section devoted to your estate management in the event you become incapacitated. This language will work in conjunction with and in coordination with your SCIAVO documents. But be careful here. Your trust provisions regarding incapacity must be coordinated with the SCIAVO documents or problems may arise. Let's talk about how your living trust can protect your surviving spouse. When it comes to protecting assets, there are three primary areas of concern a surviving spouse will face. The first is the potential for lawsuits. Now, I don't have to tell you that the latest and greatest get-rich-quick scheme in America today is to sue somebody. And when you are sued, everything that is in your name, with minor exception, is available to pay a judgment if you lose. In the normal death plan, the surviving spouse has little or no protection at all from a judgment creditor. Everything that he or she owns or can access is susceptible to loss. Conversely, in a properly prepared life plan, the assets of the decedent can be substantially protected from this type of liability. So if the surviving spouse were to get into an automobile accident, or someone slipped and fell on the residence driveway, or the dog bit someone, or if any number of other possibilities that might create lawsuit liability were to occur, a large portion of the estate could be protected against loss due to any one or more of these possibilities. The second area of concern revolves around the risk of remarriage. Do you recognize the picture in the upper right-hand corner? That's right, it's Anna Nicole Smith and her billionaire husband, J. Howard Marshall. How do you think the original Mrs. Marshall might have felt about her half of the Marshall estate going to Anna Nicole? This can be a huge problem that the death plan just does not address. In fact, the surviving spouse under a death plan will usually have no difficulty using the decedent's half of the estate any way he or she pleases. The life plan, however, has protection components that would make it much more difficult for the surviving spouse to use the decedent's half of the estate for purposes never intended. The third area of concern revolves around the risk of inadvertent disinheritance. This might arise when the surviving spouse withdraws money from the decedent's trust and keeps it under the survivor's own name. If the survivor were to then remarry and thereafter pass away, those dollars could wind up going to the new spouse of the survivor, who then sends that money to his or her children, not your children. All of these scenarios are merely the tip of the iceberg when it comes to the ways your surviving spouse might lose money in an unintended manner. Maintaining a protective envelope around your life's work can assure that those assets will be protected in a manner unavailable under the basic death plan. Now let's talk about how we can protect the children against these same risks. As would be expected, our children are susceptible to similar loss possibilities that our surviving spouse is exposed to. But in addition, they have a few of their own. For example, if you and your wife were to pass prematurely together and your estate was left to your 18-year-old child, would you be concerned about whether he or she could handle it? Frankly, I don't know many 18-year-olds who are in a position to manage a 6 or 7-figure estate without inappropriate spending or loss. Another risk to be faced is the possibility of your child's spouse taking up to 1/2 of your life's work when that spouse divorces your son or daughter. Without proper life plan safeguards, both of the above scenarios are very real possibilities that do happen more often than you know. Now, the risk of lawsuit liability facing your child is similar to that facing your surviving spouse. Certainly, under a death plan, if your child were found liable for any tort or contract action, your entire estate could be at the mercy of that plaintiff's attorney without much protecting it from total loss. Under a life plan, however, your estate may be protected from such loss in a manner that only you can assure. Doesn't it make sense to provide that protective envelope against the possibility of loss due to a potential or actual lawsuit? Another risk revolves around the possibility of financial difficulties driving your child into bankruptcy. As you might expect, if your estate has been passed under a death plan to your child in his or her name, the bankruptcy judge will consider that money to be in your child's estate and, as such, available to pay his or her creditors. In a properly prepared life plan, however, your estate would be unavailable to your child's creditors even if bankruptcy was an unfortunate part of your child's future. And just like the risk you face in relation to your surviving spouse, you must face the very real risk of your child inadvertently disinheriting your bloodline, sending your life's work to people you don't like or don't know. Imagine you have a death plan that sends your entire estate to your child, free of trust, only to have that child predecease his or her spouse. That son-in-law or daughter-in-law would then likely receive your entire estate with you hoping he or she does the right thing. If that child-in-law were to remarry and predecease that new spouse, however, I think it is safe to say your grandchildren could be completely disinherited, with your estate going to the children of that new spouse whom you never met. Not a pretty picture. Okay, so what about protecting the grandchildren? Well, as you might imagine, all the risks we've been exploring around the protection of assets for the benefit of your spouse and your children against loss due to creditors, predators, divorce, bankruptcy, or inadvertent disinheritance will be faced by your grandchildren also as they grow into adulthood, unless you take action to protect them. But there are several other risks that require your understanding that relate to the grandchildren solely. For example, are you interested in assuring the grandchildren receive some portion of your life's work upon your passing or the passing of your children? Unfortunately, the basic death plan does not provide for that. The life plan does provide, however, a structure to assure that whatever it is you want your grandchildren to have will be received by them. Further, your grandchildren may wind up paying an estate tax which, if properly set up, could have been avoided. That is, received estate tax-free. Through proper use of the generation skipping transfer tax exemption, the grandkids can receive estate tax-free money that otherwise would be estate taxable. Also, within certain limits, what you allocate to the grandchildren can grow to any amount without paying any estate tax on that growth. So you see, when it comes to your family, many different things, whether positive or negative, can and do happen. Whether any one or more of them does happen will depend upon the quality of the estate plan you create for your family's benefit. The most important element here is your understanding of what's going on. I trust this presentation was useful in helping you make some very important decisions. So, once you've prepared your personal estate plan, how do you assure it will remain current and consistent with your overall goals? The answer to that question is set forth in our next presentation.